Now, so you do your people, I'll remove.
Okay.
I'm still smiling.
The sub-regulation 1, the order convening the court and the names of the officers appointed to try the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings on day 1, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that is announced on day 1 is the panel that ought to have continued. Even on the day Eron Kizza was tried and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also.
It says every person who is right, that's a right to a fair hearing, every person who is charged with a criminal offense shall, when you go to D, be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, offense, you cannot say that when we have 30 lawyers here, Eron Kizza, who was convicted by this court, is not there, and therefore the right to a fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted before this court is not there, and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no, and if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30, and Kizza has a specific role to To me, that doesn't make sense. I think I'm done, which talks about the duties of the judge advocate. Sub-regulation 1 says that the prosecutor and the accused respectively are at all times after the judge advocate is named to act at the trial entitled his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, calling this court a tribunal, that one will not happen. The UPDF Act defines the court-martial as a field court-martial, general court-martial, or court-martial appeal court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintend over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adopt dictionary definitions.